Assalamualaikum warahmatullahi wabarakatuh. Hello, selamat pagi. Good morning, ladies and gentlemen. I am Nadira Samara, and I would like to welcome you to the Asia International Public Webinar in collaboration with ADCO Law 2021 with the theme, The Upcoming Trends of Mining Dispute in Indonesia. So I will explain a brief background about ADCO Law. It is established in 2008. ADCO Law is a full-service law firm providing clients with a wide range of legal services from corporate formation, acquisition, and shared investment, complex construction arrangement to company dissolution. Again, I would like to explain the rules for today's webinar. So the first is participants can change the name with format full name and institution. Second, if there are no technical matters, participants are required to turn on the camera. Third, during the session, participants are required to mute the audio. Fourth, our Zoom admin team has the right to mute the participants who are unconducive. Fifth, participants can raise questions using the raise hand or chat box tools during or after the session ends, and moderator will guide for the Q&A session. And last, for documentation, we would like to record all the session for today. The background of this webinar is because of the COVID-19 pandemic has changed the business world in general. The mining sector is one of the business fields that is affected by this situation. The price of the commodity is rising recently, while disputes in the mining industry are still possible. Today, our honorable speakers will deliver their point of view on the regulatory framework of the mining dispute between Indonesia and Singapore following the recent cases, the impacts of COVID-19, and the upcoming trends. Without further ado, let's begin the first presentation, which delivered by Mr. Dendi Adisuryo.
Hi, morning. Thanks, Bu Nadira. So I'll be the first speaker, yeah?
Yes, sure. So I will share for the slides.
Yep.
Okay, Pak, the slides ready.
Thanks for Nadira. Thanks Nadira for hosting us. And before we start with the webinar, I'd like to express my appreciations to all the speakers here. We have Pak Kendista, we have Pak Bazul Asa from Singapore, Pak Kendista from SIAC, and also Pak Wala Adol from Bani. I think it's quite an honor for me personally to be on board with you, Bapak-Bapak, to share the ideas on the mining dispute in Indonesia. So I hope discussion can be something very useful for us, because it's quite relevant, because like Nadira said before, now the industry, especially in mining industries, goes up because the price is getting better and better compared to what we have last year, and I think this year will be interesting for the mining industry. And also, I'd like to say hi to all the participants we have here. I've been told by Asia that we have more than 300 participants here. I think it's quite a huge number, showing that the interest of this topic is quite high. Okay. I have 15 to 20 minutes, so maybe I'll give a presentation in a bit quite manner. So maybe can next to the next slide. Okay, this is the agenda of our presentations. The first is the most common mining dispute in Indonesia, the causes and the root of the problems. The second is about the mining cases profile handled by ADCO within the last 5 years. So I'll provide some illustrations on how the mining dispute is happening and what kind of dispute handled by us for the last 5 years. And the third is the driving factors of mining dispute trends in 2021. At least two things. The first is about the new law. We have two laws, the relevant law, the mining law and the omnibus law, Undang-Undang Cipta Kerja. And the second factor is about the price. We'll discuss a bit later on that issue. The fourth thing is the challenges for the dispute resolution in Indonesia, and the last on the practical suggestions. On the first slide, I want to discuss about what are actually the mining disputes coming from. because in Indonesia, like other countries, the mining industry is a bit complex compared to other industry because it involves many industry, it involves many regulatory regime. Yeah. Once we are talking about mining industry, then we're talking about the land acquisition, we're talking about the concession, we're talking about the transportations and logistics, we are talking about the land acquisitions. There are so many things mix one to another. So it will create some sort of vulnerable points where the mining activities can be disrupted due to the dispute. Yeah. So these are the four things that usually coming as the root of the problem or the source of the dispute. The first is on the sale and purchase commodities. Yeah, we are talking about coal and mineral sale and purchase. Can be domestic, it can be offshore transactions. The thing is that sometimes we have delay in the delivery schedule. Yeah, the seller fails to deliver the cargo on timely manner, so it will create a demurrage. If, for example, if the price is on the CNF or CIF, or so the buyer will have to pay demurrage to the mother vessel owner as the charter. Yeah, and the price and the demurrage rates is quite significant. That's sometimes with the problems in the practice. Second is on the price adjustment. Normally in Indonesia, like other countries, the price of wholesale trading is set up based on certain parameter, but on the actual delivery, the quality of the cargoes is not exactly the same with whatever the parameter agreed in the agreement. So usually we have some sort of adjustment price clauses. Uh, for example, if the quality is less than the 15%, then the price will be adjusted 15%. But then again, sometimes the quality hits the below parameter, the bottom line. So it will create rejections of the cargo or additional discount of the price, and that in our observation and experience create the potential dispute between traders and buyers. The next on the non-delivery, yeah, the seller fails to deliver, maybe because force measures like what we have right now, COVID-19 or bad weather, so forcing mining companies to stop the operations, or they can do the mining, but they cannot transport the cargoes, yeah, because the flood, yeah, or the hauling road is blocked by the local community, so they just can't do the delivery, or no performance at all. Yeah, we've seen before a transaction where the buyer will have to pay some sort of advance payment, normally 50%, yeah, in advance. But then after the advance payment is made, there is no coal delivery. We've seen a lot this kind of practice, especially if you are dealing with small miners, if you are dealing with the mining companies who has productions less than 2 million metric tons per year, for example. That's something quite frequently happening in Indonesia. The next on the concessions, yeah, on the validity of the concessions. The first is on the sale and purchase of the commodity. The second is on the concessions. Concessions, the most traditional problems with the license is two. Yeah, the first is overlapping. The second is revocations. Overlapping, I'm not talking about overlapping between one mining companies with another mining companies, but it can sometimes happen overlapping between mining companies and other type of industry, for example, for plantation or power or oil and gas. So the law says that the legal framework says that as a mining company, we have to settle with the landowner. But at the end of the day, if there is no settlement, if there is no commercial arrangement between the parties, then we need to settle it through court, overlapping between the mining companies, and revocations, cancellations of the license by the government. As you know, the government has an authority to issue the license, but at the same time to review performance of the mining companies. So if the government finds that one of the mining companies failed to perform its obligations as a mining companies, then the government may use its authority to cancel the license. It's not only the license. Yeah, last year we seen quite a big termination of one of the CCOW, and then it's followed by criminal and investigations. And and now after the enactment of the new law, I think the landscape will be a bit different, because the authority for the licensing is taken back to the central government. And I believe there will be quite cases, where the central government see that the license issued by the local government were not properly reviewed, and then the central government may take further decisions to review any license issued by the local government. Next, on the change from contract to license. In Indonesia, there are two types of concession. The first is contract basis. We call it CCOW or COW. It's actually a contract between the mining contractor and the government. The second type is the license, the IUP, IUPK, or IUPOPK. Now, under the new mining law, law number 3/2020, which was enacted last year, all the contract will be converted into the license, but subject to certain parameters. So I believe maybe we have more than 100 CCOW and COW company in Indonesia, but I believe it won't be 100% be converted. It will be maybe 70 or 75%, whilst the rest will be, will be terminated or hanging by the government. That will create a loophole for the dispute a lot in the upcoming years. Okay, the next is on the lending and borrowing activities. Most of the mining productions activities is sourced from third-party financing sources, not from the internal cash flow of the company. So it involves lending, borrowing activities. And we've seen during the turmoil of the coal price or mineral price that the miners fails to pay the debt, inability to repay. And we've seen also breach of financial or technical governance, in the facility agreements, like default in the KAMA or cost waterfall mechanism, and debt restructuring. And also on the investment side, these are the dispute that coming from dispute on M&A related matters, whether it's from the rep and warranties dispute post closing of acquisition transactions, or working capital adjustment dispute if the party agreed to set up the price based on working capital adjustment mechanism. And also mine development agreement, or we call it traditionally here in Indonesia as SPK. SPK is basically an arrangement where mining companies do only the licensing and the social problems, while the operational activities are taken care by the contractors. This practice is actually not allowed yet, because there is a specific regulation saying that the mining company will have to do the mining operations by itself. It cannot appoint a party to do the core activities. But again, in the reality, we've seen a lot this mining agreement or the SPK model transactions, which actually very fragile in a sense that if one party thinks the arrangement is not beneficial to it anymore, then it can create a problem by saying that this mechanism is illegal, and they can start doing the litigations, canceling or revoking the SPK arrangement. And the other is on the dispute in share transfer. Again, in Indonesia, we still seen a lot dispute in share transfer. The transfer of shares was concluded back 10 years ago, and then it is litigated again today. We've seen cases like that before in Indonesia. And nominee arrangement, because nominee arrangement is commonly practicable in an industry where there is a maximum ownership of foreign investment. So the foreign investors comes into the pictures through the nominee arrangement. Before the Indonesian investment law 2007, there is no prohibition saying that nominee arrangement is not legal. Yeah, but after the new investment law, there is a strict provision saying that nominee arrangement is legal. And again, it is not quite common, but we've seen one or two cases about the nominee arrangement dispute. But the problem is once it explodes, then it will collapse the whole investment made by the investors. These are the mining case profiles handled by our office since 2016. If you see there, the criminal point is take the majority, the second majority. The first is the lending and borrowing. In the criminal, we've represented clients because the fraudulent acts by the local partners, yeah, the non-performance, the falsification of applications of documents, and we've done also the investment dispute or administrative dispute in Tetun, overlapping between one mining companies and other mining companies, but with different commodity. Investment dispute, acquisitions, pre-shipment commodity sales, where the client pay some sort of money in advance, and then the seller, the supplier, fails to provide the cargoes to the buyer. And mining activities is on the technical side, is on the relationship between the mining concessions and the service provider, where the conflict was about the coal loss. The project owner, the mining concessions, claim that the mining service providers mistakenly conduct the mining operations, so it caused coal loss, significant coal loss to the concession owner. And commodity sales, with assisting for demurrage claim for the delay in the cargo delivery. That's the profile of mining cases. And about the forum, this is the number of the percentage number of the forum that we have working on. BANI, SIAC, KCAB, and Indonesian court. Maybe it's quite interesting because the Indonesian court still play a very majority role, yeah, 80% compared to the BANI only 7%, SIAC 5%, and other foreign arbitrations 2%. Yeah, next slide. I'll be discussing about the driving factors for the mining dispute trends in Indonesia. The first, of course, about the price. Yeah, if you see now, it is the data taken out from Minerba. The price is a bit slowing down in the mid last year, and it reached the lowest level on the September. And during the period that the operations, there are many coal company which close their operation temporarily, or even some of them close the operations permanently. And we've seen from discussion from the industry that the price will keep the positive trend until next 3 or 4 years. Because of a couple of reasons, the China, America trade wars a bit slowing down. The economic is about recovering this year. So the global consumption will increase, and of course from the production side, there will be positive corrections on the price. And this will be one of the major dispute trends from our observations. Anytime the price of coal goes up, the number of dispute goes up. That's something happening constantly back from 2010. Yeah, wherever the price goes up, then the dispute of the coal will goes up. How the price can affect the mining dispute? Yeah, because first, of course, the local the producer, the coal producer will increase the productions. They'll buy more equipment. They'll do hiring more employees. Yeah, and reopening the mine site in Indonesia. There is a distressed asset. There are distressed asset, number of distressed asset for coal activities, coal companies. But now, since the Q4 of 2020, people start to reopening the mine site here in Indonesia, especially in East Kalimantan, South Kalimantan, and Central Kalimantan. And these activities will create more, relationship between the parties, between the subcontractors, with the vendors. The bank will come in to provide the facility for reopening the mine site. And what I'm predicting is there will be new deals of coal and sales purchase agreement between new players, because when the prices goes down, when you make only 50 cents or $1 per ton, then only big names, only big players, only old players who play the game. But when you can make $5 per ton, then everybody will come in. So I believe that there will be quite numbers of new deals enter into the new players in the coal and mineral industry. The next is acquisition and new investment. The data from PricewaterhouseCoopers shows that for the last 2 years, acquisitions in coal and minerals a bit slowing down. It's not a bit slowing down; it's slowing down significantly. But we are predicting 2021, the acquisition and new investment in coal industry again will increase significantly, driven by the price factor. Land acquisitions, because everybody want to start the operation or restart the operation or open new activities, then land acquisitions will commence progressively on the side. Maybe if you work in the mining companies, you have encountered that particular work right now. And development of the supporting infrastructure. The existing infrastructure will absorb only the existing production capacity. So if the price goes up, the production will be increased. Of course, the supporting facility will be developed, and this will, of course, create a potential problem in terms of a dispute in the future. And this is what are the predictions we've made for the dispute on 2021 for the investment in coal. The first is for the investment, like acquisitions or mine development agreements. Yeah, because like I said before, if you get only small numbers of profit, there's not so much people willing to start the fight. But if you are getting, let's say, big numbers of profit, then you are willing to start the fight. So I think that's the prediction we have in terms of dispute in investment, either in M&A or in mine development agreement, will start to begin maybe in the next quarter, while the price will hit $90. I believe the number of dispute will be increased significantly, and the overlapping between the mining companies and other mining companies, overlapping between mining companies is not so that high in the possibility, but overlapping between mining companies and other concessions, for example, for the plantation or HGU. Because if we want to start the operation, there's no other option that we have to take over the land, and then it means we have to be face on face with the landowner. Yeah, and based on our experience, every time we want to start the new mining operations, the possibility of dispute with the landowners will increase either in the administrative court by way of canceling the license or canceling the rights, or commercial dispute in the district court. Next on the M&A disputes, like what we have in the investment, and the next on the cross-border coal and mineral sales, because the demand is increasing, numbers of transactions increasing, and people tends to enter into new deals with someone who has previous long-term relationship, and of course it will create a degree of complexity if we are dealing with the person who has no track record in the industry. Okay, the second driving factors for the mining dispute is the regulatory changes. Yeah, like I said before, there are two laws regulating mining industry at the same time. The first is mining law, number 3, 2020, and the second is Omnibus Law, Undang-Undang Cipta Kerja, number 11, 2020. These two laws, for some degree, set something new about the mining industry, which may change the industry landscape forever. Yeah? Because the first is about the centralized regime. Yeah, if we see under the old mining law, yeah, under the old mining law, law number 1167. And changed to law number 4 2009, the licensing authority is with the local government. It was taken back, semi taken back, not to the central government but to the provincial government on 2014, and now on 2020 it is taken back to the central government. So all the licensing authority will be with central government. And the second is on the conversion of the CCOW and COW to the license. And the interesting point in the conversion is that the CCOW or COW company are guaranteed to be converted, but subject to certain criteria to be set up later on by the government. What does it mean? It means that there could be a situations where the CCOW companies got not converted into the license because the government say, okay, after reviewing your performance, you are not meeting this criteria. That's why we are not converting your license. We will terminate your license. So these two things, I believe, will create a lot of potential dispute on the ground level for the centralized licensing authority. That's true that the authority to issue the license is taken back to the central government, but not with the supporting license. For example, for the environment license, for the technical license, some part of the licenses are still with the local government, and conflict quote unquote, yeah, between local and central government sometimes is brought in the reality between the parties. Yeah, so that's point number one. Number two, revocation of troublesome license which were issued by the local government. See, before, we have now in Indonesia about 9,000 mining concessions in terms of IUP in terms of license. Yeah. And by taking back the authority to the central government, I think the central government will try to scrutinize the license issued by the local government, which is not properly managed, yeah, or which is overlapping one and another. So I believe there will be some corrections made by the government in the upcoming years, because that's the point. That's the idea of taking back the authority to central government. And on the right side, on the conversion of the CCOW, like I said before earlier in these presentations, from hundreds of CCOW company, I believe there's only 60 or 70% which will be converted, while the balance mostly be terminated. So, of course, the only options from the company who has the contract is terminated is only submitting a claim in the arbitrations, and in CCOW or COW, the choice of dispute settlement is the foreign arbitrations mechanism. So these are the things with the regulatory changes. And now the fourth point is about the challenges of dispute resolutions in Indonesia. I think this is coming from a very practical point of view, yeah, not theoretical or legal framework, but it's very practical. The first is the long process of proceeding in Indonesian court. I think it's a very, it's a very old problem, yeah, in Indonesia, that we need to spend at least 2.5 years to have a dispute concluded, started from the day one when we submit the claim to the panitra, to the court clerk, until the final award issued by the Supreme Court in terms of appeal to the Supreme Court or appeal against the Supreme Court decision, or we call it PK, peninjauan kembali. So that's something that always be the case with our proceeding in Indonesia. The long process, it takes 2.5 years to get it done from the day one. And because of this pandemic situation, I think the situation's getting a bit worse. Yeah, because from our experience in the last 12 months, every time we found a new case in a court, then the court decide to stop the whole proceeding. Yeah, they lock down the court physically, and the proceeding will be delayed for another 2 weeks or a month. Every time we found a new case in a court. Yeah. In Indonesia, there is no institutionalized virtual proceeding. Yeah, especially for civil case. We do have for the criminal and some sort for the commercial, for the niaga, yeah, for the PKPU, but for the civil case, there is no institutionalized virtual court proceeding. So we have to manually and traditionally attend the case physically, and of course, until the pandemic is resolved, this will create a problem. And travel ban and restrictions when we want to go out, either in Indonesia or outside Indonesia, or even outside Jawa, yeah, because most of the disputes, not only in Jakarta, but sometimes we have to travel in Sumatra or Kalimantan, and travel ban or restrictions, it will create the situation is a bit worse in terms of the speed of proceeding. The next challenge is on the enforcement of the international arbitration number. I believe Prof. Wala and Pak Kendista may provide a better explorations on these things, but this is the data that we get from the Pengadilan Jakarta Selatan. But I think the data is a bit surprising me. On 2018, there's only 10 registered international arbitration award in Jakarta Selatan, and the exequatur decision only 5. And 2009 registered is 10, the exequatur is 11, because one is from the previous years, and the objection by the losing parties only 1 case. I think I'm not sure about the quality of the data that we've got from the PN Jakarta Selatan. But I think Pak Kendista and Prof. Wala can explore better. But if we see this number, I think I think the situation is getting better compared to the last period. Yeah, because if we are talking on 2016 or 2017, I think most of the losing party will submit objections against whatever international arbitration award is registered in the Central Jakarta. So this is the challenge in enforcing the international arbitration award in Indonesia. And the next challenge is on the transparency and fair trial. This is the numbers we taken from KPK website. I think yes, we are still struggling in getting our judicial system better in Indonesia, but from the numbers, I think the numbers is slightly better compared to back if we are talking about data from 5 years before. Transparency and fair trials is still a challenging point in Indonesia. This is the numbers that you can get as an illustrations. And these are the practical suggestions on how we should handle the dispute in mining industry. Number one is understand who will be your counterparties. You have to understand who will be your counterparties, whether they have a proven track record, whether they have a financial source, whether they have asset, because sometimes winning a case on paper doesn't mean it will recover your money back. So you have to understand who will be your counterparties. If you are not sure, then it's better for you to ask a personal guarantee or corporate guarantee from the holding companies. So just to make sure that every time you win the case, then you can materialize the case to recover the investment you've made. Second is proper commercial arrangement and risk mitigation. Of course, this is always the case if you want to do the mining investment in Indonesia. The commercial arrangements, maybe it's commercially okay, but sometimes it is not in line with the legal framework. Like I said before, SPK, it is very common, but it is not legally okay to have that SPK arrangement in Indonesia. The third is strong contract admin on the side, because sometimes winning or losing the case is not based on the big documents, it's not based on the main documents, but sometimes it was from minor documents, for example, berita acara or minutes meeting in the site, in the job site. So we strongly suggest that every mining companies or contractor companies to keep the strong administrative contract team in the site. Next, on teaming up with technical and financial experts for mining dispute to determine the liability and quantum. Yeah, because for example, if we are discussing about the coal loss, it's very technical, and it's almost impossible that the lawyer will have to explain by himself or herself. So we have to teaming up with technical or financial expert to make whatever argument we've made before the court be more sensible. And the last thing is on the regular compliance due diligence, just to avoid sanctions either from the government because we are not complying with government regulations, or sanctions because we are not complying with whatever requirements a contract you've made. I think that's the presentations that I can provide. Maybe we can continue with the Q&A on the later on session. Thanks, Nadira.
Thank you, Pak Dendi, for the explanation. And I would like to apologize for not showing the CV of Mr. Dendi. So maybe I can show the brief CV for Mr. Dendi now. Sorry, Pak.
I think that's no problem. We can continue. You make me shy. Yeah?
Okay. Okay, Pak. Noted, Pak. Okay, so next, it's Mr. Bazul Ashab, the managing partner and head of dispute resolution at ADCO and Bazul LLP Singapore. Hello, Mr. Bazul.
Hello.
Okay, Mr. Bazul, the time is yours.
Thank you, Nadira. And thank you, Pak Dendi. Thank you, Pak Ibu, for attending the seminar. I found Pak Dandy's presentation most useful and helpful. I want to touch firstly on what Pak Dandy said, and touch on how we could collaborate more effectively when we between Indonesia and Singapore first. Now, one of the things which Pak Dandy raised in his presentation was that the lengthy delays which takes place in Indonesia. So the idea behind whenever there's a dispute, the key idea is a resolution of the dispute. And a delayed resolution may well deprive the winner of an opportunity to enjoy the fruits of the labor and the profits of the dispute resolution process. So the collaboration which I have in mind, which has worked superbly in other cases and in the past, and it will continue to do so, is how we, from the Singapore side, and how Pak Dandy can then work together in order to resolve any disputes which takes place. So there is an alternative, whether it is Bani arbitration or SIAC arbitration, depending on where the eventual enforcement is likely to be and who are the parties involved, are there international parties, which you can then use to effectively, quickly resolve the dispute. And when I say use Singapore arbitration, it is not an exclusive affair. It's an inclusive affair. What I would strongly recommend, and I say this to my Indonesian clients as well, please continue to instruct your Indonesian lawyers, because that's critical for your interest. Because a lawyer like Pak Dandy, who has been around for so long in this field, would be able to assess the cultural nuances. And from his presentation, he also explained very clearly how the regulatory nuances will come to play and can invoke as a way to prosecute your claim fully or defend the claim. And he also understands, given that he has been working with the Indonesian clients for the longest time, the cultural objectives. And culture makes a very important play when you are giving evidence, when you are being cross-examined. And it's actually more cost-effective, and I found it often to be the case, when we work together with someone like Pak Dandy, rather than instructing me directly, because Pak Dandy being in Indonesia would be able to extract from you what is relevant for me to present in a Singapore arbitration. That way, cost is not expended unnecessarily, where me trying to understand the basic facts. This would allow your dispute to be resolved very quickly. And when you're talking about an arbitration, we are talking about within one year or so, you would be able to resolve the arbitration. Now, so I've touched on collaboration. Now, I want to touch now on the disputes which I have encountered in the past, which is likely to resurface with even more aggressiveness given the COVID pandemic which we are facing. History is always a useful subject matter, because it has a very bad habit of repeating itself. Now, no one could have predicted, the wreckage COVID-19 has brought to the world's economy. Most of the mineral commodities, except gold, have seen their price hit lowest level in years. Coal trade was also not spared. Obviously, this has a significant impact on Indonesia, given that it is one of the world's largest exporter of coal. with an industry that contributes about 4% of the country's gross domestic product, mostly through exports to China and India. Now, when COVID hit the world, I was involved in advising what would be the position buyers should take, given the lockdowns which have been imposed by several ports, and could we declare force majeure situation? And if we declare force majeure, what would happen to the seller, and what would happen to the shipping company and the ship which is carrying the coal? So I was very heavily involved in resolving those disputes when there was a severe lockdown, when the first wave. Now that has eased, trading is going on. Trading is now progressing. Now, so I want to touch on firstly the dispute which are likely to come, and how do you mitigate those disputes. But Dandy touched on counterparty risk. This is extremely relevant, as Pat Dandy said. I accept from those who are involved in the trade perspective, it's easier said than done, especially when you're dealing with a depressed market. You need to sell. You can't keep your coal. You need to sell. And not everyone who would be able to put up a guarantee, which is the best way to mitigate your risk. But if you can't get that, what do? You could go and carry out searches on the financial capacity of those who are involved, or want to be involved in your trade, by getting experts. There are many those service providers who will provide searches for you. And the other maybe unconventional way of looking at it is to see whether there is any court proceedings filed against those who are interested to contract with you. Many don't do it. Some do it. And that search, when it revealed that the counterparty has court proceedings, has actually avoided headache and the party who has done the searches. We have done the searches before, and our clients have not entered into a contract after finding out that the party who intended to contract has a huge claim which is pending in the Singapore courts against them. That I think that saved a lot of headache. Now, so I've dealt with this in terms of the counterparty and what's their business model. What you could do is instruct third parties to carry out these searches. Can we go to the next slide? Okay, maybe I should just speak. I mean, if you don't mind, I mean, the slides can well be distributed if it is not already done so. Now, I'm going to talk about the survey and inspection clauses. Now, you may be familiar with a clause which is commonly found in coal contracts, which provides that a finding of a surveyor at a load port is final and binding. That clause has been upheld both in the English arbitration, Singapore courts, English courts, because the rationale behind that is if you agree to have one expert make assessment on the quality and the quantity of the dispute, then you are not allowed to dispute it. And the thinking behind that is this needs to happen before the cargo is loaded. Once the cargo is loaded, it is extremely difficult to have a dispute. And then what do you do with the loaded cargo? So this is a mechanism in order to avoid a dispute. Now, I did a court of appeal decision and trial and a court of appeal decision called Jimpex and Unity Holdings business. There, in that case, there was the clause which said that the load port, Sukofindo, it was Sukofindo, Sukofindo's survey was final and binding. But there were other clauses which provided that there would be an independent inspector who would be appointed, and the methodology which the independent inspector will employ in order to collect samples and sample the coal which he would collect. And in that case, there was a dispute whether Sukofindo's finding was full and final. So one of the arguments which was run was it is not, because given that there were other clauses which allowed other third parties to also assess the quality of the coal, Sukofindo's, there was no intention by the parties to the contract to have Sukofindo's certification to be final and binding. And the court agreed with the argument. So when you are doing up a contract, please make sure that if you intend, especially from the Indonesian side of business, you want your surveyor's finding to be full and final. Please do not allow any other clauses to be introduced into your contract which will reduce that finality. So now I've done that. Now there's the other point which I wanted to touch on. This is another arbitration I did in London. There, the question of dispute was when parties use the word typical. There, the parameters provided that fluidity typical was 500 ddpm, MMR typical 1.2%. So when layman will say the ordinary use of the word typical will mean average, usual. However, this tribunal found that the word typical meant that the sellers had to conform to the specific numbers of 500 ddpm fluidity and 1.25 mmR. That came as a shock because it was not intended by parties, by the use of the word typical, to give a warranty. Because if they had intended to warrant, then they would have set the rejection limit, or they would have used the word warranty. So this tribunal, I think, got it wrong. But it is those who are familiar with this would know that it is not easy to appeal against a tribunal's finding. In London, you need to find a point of law which the tribunal has made a mistake. This may not be a point of law. This may be a point of fact. So there no appeal is allowed. So I thought it is useful to bring it to your attention, again from the Indonesian side of business. If you had not intended for these words to be used, the word typical to be used as a warranty, you should indicate that. Now, the next point I wanted to touch, and this is so close to the heart of the present conditions, COVID. You find ships waiting with cargo. You find ship owners' freight is not paid. In such a case, the ship owner will then exercise his right of lien to protect, recover the freight. What does that mean? What it means is he takes security over the coal and then says, I want to sell the coal in order to recover whatever freight which has been paid to me. There would be a fight between the interest of the buyer who would have already paid for the coal by using his LC payment. And for all you know, the seller, if assuming it is a CFR contract, the seller will then may not have paid because the seller may have gone insolvent. In such a case, what happens? So depending on the terms of the bill of lading, depending on where the jurisdiction is, I have had a case in Singapore where the Singapore courts granted the right to the ship owner to sell the cargo and recover the proceeds. So from the buyer's perspective, that needs to be looked at. That risk needs to be looked at. And this needs to be also borne in mind when you are dealing with your counterparty. As Pak Dandi said, and I touched on, when you're dealing with the counterparty's risk of insolvency, you need to assess whether your right to your cargo may well be affected because the ship owner may then exercise a lien. If the ship has been waiting there in the load port, say several days, I've have situation where a ship had waited for 70, 60 days, and then because of the lockdown at the discharge port for another 50, 60 days, you are going to see a huge freight claim. So you need to take on board that as well. Yeah. Now, next slide is, sorry, what am I going to do? So I'm going to talk about the preemptive steps which we can take. And I mean, maybe in the panel discussion, maybe you can, talk slightly more. Maybe Pak Dandi and I can jump in and say what is available to you. The first thing which comes to my mind is this: an injunction to prevent payment on an LC. So if there is a fraud, it has to be elevated to that. If there's some semblance of fraud, that the cargo which was loaded is nowhere close to the contractual specification, I've actually gone in and obtained an injunction against payment of the LC, so that I would be able to sit and negotiate a settlement. An injunction remedy is a very powerful remedy, or there were multiple bills of lading which are floating. If you think that someone who is not entitled to the cargo is going to get his hands on the cargo, you get an injunction to freeze, to stop anyone getting a claim on the cargo. Now, the next, what I spoke about now is called a Mariby Injunction. A Mariby Injunction is where you have a claim against it, and if the claim takes a long time to process, and this particular third party then says, okay, might be easier for me to transfer all my assets to another company and drag this proceeding. By the time the plaintiff obtains an judgment or an award against me, he can merrily go and wind up the company. I've taken all the money, the proceeds of the sale as well, park it in another company. I cannot be touched. I open another company and start this business all over again. Where there is a risk of that happening, you are entitled to go to court and obtain a freezing order or Mariby injunction. I don't know whether it's the science of time. I have been involved in so many Mariby injunction. In fact, I'm wearing white today because I'm going to go to court for a Mariby injunction as well. I ended the year with a Mariby injunction because I was acting for a Kazakh bank. That was probably the world's largest Mariby injunction, $5 billion. I started the year with another Mariby injunction. And I've got 3 Mariby injunctions. Probably there's so much risk of dissipation going on, given what we are facing. So that's something which you can have in mind. If you are going to think about enforcing your right to monies before your proceedings come to an end. Now, the other injunction is an anti-suit injunction. An anti-suit injunction is you have an arbitration agreement, but your counterparty then decides merrily that, you know what, I rather bring a claim in India so that I can prolong this and even defeat your claim because you're not going to come to Indian court. I'm familiar with the Indian court. Then what you are entitled to do is go to the Singapore court, assuming your arbitration provides for Singapore arbitration. You can go to the Singapore courts and obtain an injunction to stop the party from going to India. It's called an anti-suit injunction. I've done this several times. And those who have been involved in arbitration and the Singapore courts will know that the Singapore courts are very proactive to protect a party's right to arbitration and make sure that arbitration progresses as effectively as possible and avoid any potential delay or trickery by any party to scuttle the arbitration or delay the arbitration. So a Singapore court will not hesitate in providing an anti-suit injunction. So I've covered the common disputes. I've covered the mechanism in which you can probably secure your dispute. I understand there would be a speaker from SIAC. I'm sure he would go on to speak about the benefit of arbitration and SIAC arbitration. So I don't want to get on to his speech. So I will stop here and I'm happy to take questions at the Q&A. Thank you, Nadira.
Okay, thank you, Mr. Basil, for the explanation. And I would like to apologize for the Wi-Fi connection. We are having trouble with the Wi-Fi connection. Sorry for the delay slides, but we shared the materials on the chat box. So for participants can access this materials through the chat box that I just shared. And also we will send the materials on the email. Okay, so now let's move on to the third speaker, Mr. Candista Wanta. Okay, so Mr. Candista Wanta, as a consul at Singapore International Arbitration Center, Mr. Candista has administered numerous arbitrations under the SIAC rules and UNCITRAL rules, from commencement to the review of the award and determination of costs. The parties in these disputes were from more than 40 jurisdictions across a range of seats and governing laws, with the total sum in dispute for cases under his carriage is in excess of 4.8 billion Singapore dollars. Hello, Mr. Candista.
Hi, Nadira.
Hi, can you hear me?
Yes, very clearly.
Yeah, I can hear you very clear as well.
All right. Should I start immediately?
Yeah,
Nadira?
Yeah, Mr.
Okay.
Candista, the time is yours.
Thank you very much. Hello, everyone. Before I start, I just want to quickly say thank you to ETAsia and also ADCO Law for the invitation to speak in this event. It truly is a pleasure to be in the same panel with prominent legal figures in Indonesia and Singapore, Pak Dendi, Pak Bazul, and Prof. Hualado. And thank you to all the audience for coming and participating as well. Hopefully everyone and their family are healthy and keeping safe. So today I'm going to talk about the trends of mining disputes at SIC and how arbitrations at the institution are progressing in this COVID-19 times. Actually, I won't be saying much about the first one, the trends of mining disputes. And I believe Pak Dendi and Pak Bazul Ashab have spoken about this extensively. What I will try to do is share the trends that we have at SIC and focus on how COVID-19 affects international arbitration as one of the methods of solving mining disputes. I will also share SIC's guide on remote hearings, which I think will be of interest to the audience. But before moving to all of that, please allow me to quickly introduce SIC as an institution and share some statistics on Indonesian parties at SIC. Okay, if we can show everything on this one. So SIC was established in 1991 as an independent and not-for-profit organization. Back then, we only received 2 cases with us. Fast forward to 2019, we received 479 new cases on top of over 800 active cases. And last year, we received more than 1,000 new cases, an increase of more than double from 2019. And it's a great milestone for SIC because this is the first time SIC passed the 1,000 case threshold. So it's a really encouraging development for us at the institution. Interestingly, more than 80% of cases at SIC are international in nature. And out of this 80%, more than 50% have no connections to Singapore. We're going to talk about the statistics of foreign users at SIC in a bit, but this highly international nature of SIC cases means that SIC has been trusted as an effective, efficient, and most importantly, enforceable means of dispute resolution by business actors not only in Singapore or Asia, but all over the world. And speaking about enforcement, SIC awards have also been enforced in many jurisdictions, including in Indonesia. So this chart shows our progress in terms of cases filed of the years, save for 2020, because we have not formally published the stats for last year, which is usually done in February or March. So as you can see, the growth is pretty exciting, quite steep, especially from the end of thousands until now. The increase is quite significant. And these are the top foreign users of SIC. Indonesian parties, I have to say, have been included in this list for about 10 years now. There are so many Indonesian cases filed at SIC. In 2019, as can be seen on the slide, Indonesian parties are ranked 7th with 39 parties in total. India and China are always in the top 5. 2018 saw Indonesian parties in number 5 with 62 parties in total. It's actually higher than last year, but the sum in dispute is lower. We're going to talk about this in the next few slides. But what's interesting is US parties broke the record in 2018 by sitting on the list for the very first time in SI's history with a total of 109 parties. And in 2017, we had 32 Indonesian parties, which was placed in number 8. So again, you can see that Indonesian parties are one of the most frequent users of SIC, always included in the top 10 list. Just very quickly on the sum and dispute, the trend is increasing from 2017 to 2018 and going even stronger in 2019, even though with lesser number of parties, as we mentioned, as we discussed previously. But this actually means that in 2019, Indonesian cases filed with SIC are getting even more complex and even more high profile because the sum in dispute much higher than the previous years, even though the number of parties are not as many. So the cases are getting more complicated and high stake. These are the categories of disputes for Indonesian cases. And from this point on, I will creep in slowly to our brief discussion on the trends of Indonesia mining disputes SIC. So 2019 is dominated by trade disputes with construction cases in second place, followed closely by corporate disputes. I'm sorry, the other way around. Corporate in second place and followed closely by construction disputes. In 2018, 3 years ago, interestingly, Indonesian cases were dominated by maritime or shipping disputes. We actually met a group of Indonesia's enterprises a while ago, and they said that the price of commodities went crashing down in around 2017, 2018. And they say that's probably why the number of disputes in the category is much higher. 2017 actually saw Indonesian cases spread out quite evenly among the categories, but trade was strong, just like in every other year. Now, When it comes to mining disputes, these are also very well spread out at SIC, Indonesian disputes. We do not see mining cases involving purely technical mining issues dominating the cases at SIC. There are those cases, but disputes involving mining companies are again well spread out in other categories as well. This is also why I shared information about the categories of disputes earlier. For example, we see mining companies involved in corporate disputes. Usually, the issues concern the right to sell shares of a mining company or put option issues or the valuation of the share price itself, fair market value, cost basis, assets, or any other basis. That's for an example for corporate disputes. We also see mining companies engage in commercial disputes in general, which, among others, concern failure to secure mining licenses within the agreed time frame in the contract, either as a condition precedent or condition subsequent, as agreed by the parties. Next one, we also see commodities dispute. Mining companies are involved in commodities dispute actually to a large extent. This kind of dispute usually concerns sale and purchase of mined minerals. So a mining company sells its mined minerals to its contractual counterpart, and then dispute happens. Another one is maritime disputes where, like Pak Dendi and Pak Bazul said, shipment of minerals were delayed, charter party disputes, and other similar disputes. So generally, I think the trend is pretty much the same with previous years. Although I have to say that a number of the recent disputes at SIC are colored by force majeure arguments due to COVID-19. For example, mining companies unable to operate and supply their minerals to the counterpart because of nationwide lockdown, or shipments of mined minerals are unable to be loaded to the ship because the loading port is closed due to lockdown. We also see cases where the issue lies not at the loading port, but the destination port, which is also closed because of government restrictions in relation to COVID-19. The arguments then involve free on board or FOB as one of the terms of the contract between the parties, and then force majeure, among other things. So these are the trends that we are seeing at SIC until recently. Uh, I think this may continue for some time, but since vaccinations are already ongoing all over the world, probably COVID-related disputes may not be as many as they are now. But yeah, this is just uh, yeah. Hopefully the pandemic will be over soon. Okay, so I will now move on to how COVID-19 affects SIC and its cases. In short, it does affect SIC, but we remain fully operational from the very beginning of the pandemic until now. New cases continue to be filed. In fact, we broke a new milestone, a new record last year. And this is because as arbitration at SIC are mostly done electronically, from the filing of the notice of arbitration to issuance of award. It is entirely possible if parties do not meet in person. And our users, along with the arbitration community in general, are comfortable with this kind of format. We're going to talk more about this specifically on electronic arbitration in the next few slides before I then conclude my session. So under the SIC rules, a party can commence an arbitration by filing the notice of arbitration, the claim, electronically, including by way of emails. In fact, all other submissions can be filed by email. Unlike in perhaps court proceedings in certain jurisdictions, including Indonesia, where hearings happen physically for almost all steps from the very beginning to the very end of the case. E-litigation was recently introduced in Indonesia, but that is not the common practice yet, to my understanding, because you need consent of all parties, among other requirements imposed in the regulation. SIC started to allow electronic filing since 1997. We did start with physical method of doing things, but from 97 to date, all filings and correspondence can be done electronically. This is, of course, less costly and more efficient for everyone, the parties, tribunal, and SIC. The only physical method throughout is the hearings, evidentiary hearings, usually evidentiary hearings. So in that stage, parties and tribunal would convene in a hearing venue, usually Maxwell Chambers in Singapore, and cross-examine witnesses and experts. After that stage, it's all back to electronic means. But ever since COVID-19 happened, even hearings are done remotely. So this is one of the impacts of COVID-19 to international arbitration. We did see a number of cases before COVID, which hearings were done remotely, but that was the exception. Physical hearings was the norm. Now, most of the hearings at in SIC cases are done remotely, save for those which cannot be done remotely or needed to be conducted physically. On this slide, you can see the various provisions under the SIC Rules 2016, which made electronic arbitration possible. I'm not going to run through all these provisions. You can see the relevant part is already highlighted in red. Basically, all of this allows an arbitration to be conducted from the outset to the very end by way of electronic means, including the hearing. But of course, this does not mean that remote hearings are the only option to go. There's also document-only examination, telephonic hearings, and so on. So which one to use would, of course, largely depend on the circumstances of each given case. While we have seen remote hearings in SIC cases even before COVID-19, it is only starting to be used more frequently last year in 2020. And there are some things that need to be considered and prepared when it comes to remote hearings. Various institutions in the world have introduced their own guidelines for this, including SIC. In August last year, SIC issued our guides on taking your arbitration remotely, which is the first of the SIC guides series seeking to help users to navigate the use of audio-video conference and other non-physical means of communications in their arbitration cases. As you can see from the slide, it is presented in the form of checklist and is very handy for both users who are unfamiliar with remote hearings and those who already have prior experience doing remote hearings. The contents cover general considerations when it comes to remote hearings. This one on the slide helps to identify whether remote hearings are needed or not, possible or not, through the lens of all applicable laws, availability of logistics, and technicalities before and during the hearings. We also included an appendix on choosing the right platform, Zoom, BlueJeans, Cisco, WebEx, or others. We basically flesh out all the relevant features that one may need to consider in choosing a platform for remote hearing, from maximum participants allowed, audio video quality, data protection and security, file sharing, and many more. There is also a checklist for remote hearing procedural orders. This may be used to help parties and tribunal ensure that everything is covered nicely within a procedural order, be it the platform, transcription, recording, participants, technical failure protocol, schedule, and other things. Finally, what's interesting with the SIC guides is that we included an appendix on remote hearing etiquette. This is not actually necessary, but if followed by parties and tribunal, we think would greatly contribute to a smoother and easier remote hearing. For example, we cover how should participants identify their username, whether with /claimant or /respondent or not, and the use of mute function, dress code for the hearing, the remote hearing, turn to speak, and procedure to interject. You can easily find all of this on our website. It's very useful and may help answer some of the questions you have regarding remote hearings at SIC. This is pretty much it from me. Apologies if it's a bit over my time. I would be very happy to discuss and answer any questions that may arise in the Q&A session. Over to you, Nadira.
Thank you, Mr. Kanistawanta, for the explanation. So the first question for Mr. Dendi from Pak Halason Simanjuntak. You said before about dispute mining. What do you think, or what kind of government regulation should be corrected and issued by the government so that this matter about...
Okay, so I understand that the question is what would the government can do to improve the situation. I think in terms of the government side, I think they are now preparing a set of governing regulations as the implementing regulations of the mining law 2020. We have been told before that the government regulations, the PP, were about to issued on last October, but I think there are a couple of pending issues, yeah, especially when the during this pandemic situations and the government focused on the omnibus law. But I think immediately after the government issued the PP, the government regulations, maybe within this 1 or 2 months, I think it will be clearer uh, what will be the government policy to improve the situations, especially on the overlapping between the local and the central government. I'm myself not sure what will be the position, the last position of the government, but let's see. We can see what happens within next month or two.
Okay, thank you for answering the question, Mr. Dendi. And for the next question is from Jason Christian to all the panelists. So good morning, everyone. I would like to ask, is it possible to transfer a mining license to another party according to Indonesian law? If possible, could you please explain how? Thank you.
Okay, I think Pak Maful, I think it's very technical, so I need to answer this. Yeah, in Indonesian law, there is a possibility to transfer mining license. The only requirement is that the transferee of that license will have to own at least 51% of shares in the receiving company. So, for example, the company A, it has mining concessions based on governing regulations 24 2012. Yeah, it can transfer the license to its subsidiary, but PTA must have at least 51% shares in the subsidiary. So that's possible. Some exceptions apply for the state-owned company, yeah, but in general, 51% requirement applies.
Okay, so we have questions for Pak Dendi. How do you see dispute between coal mining companies distracted by use of lands by electricity generation company or being part of electricity program of the government of Indonesia? What is the position of the right of license holder, CCOW, IUP, and OP to the coal potential underneath comparing to the land surface used by electricity generation company? Okay, Pak Dendi.
Yeah, I think that's simple questions, but the answer will not be that simple because the regulations, the law and the regulations in Indonesia are silent on what would be the technical solutions to that. On the practical side, what we've seen a lot is the B2B discussions between the two concession holder, the mining concession holder and the power plant company. But if there is no agreement between the two parties, there is a joint statement letter made by the Ministry of Energy, the land minister, the agrarian land minister, and also the investment coordinating board, saying that if there is a dispute between mining companies, plantation companies, and other type of energy-based companies, then the mining companies will have a privilege to do the activity first. The reason behind that is because the right to do mining is not the same as the right to have the service right. So basically, there is a clear provisions that after you're done with the mining, after the coal reserve or the mineral reserve is depleted, then you have to return it back to the first condition, to the initial conditions, and giving back to the government. So that's the only guidance we have in terms of legal framework. Yeah. But most of the case, based on our experience, the solution is on B2B. But if fail to have a B2B arrangement between the parties, then the litigations sometimes is started not only on the commercial side, but sometimes we see the litigation is on the legality of the license. So, for example, the test will be whether a license which is coming out later than this license is prevail or not. So that's what actually happening on the ground level for the dispute between two concessions holders. I think that's the questions.
Okay, thank you, Mr. Dendi. Oh, so we skipped one more question from Ronald Harmoko Awang to everyone. What is the most difficult cases of arbitration to handle?
This is addressed to me or to Pak Kendista, or?
I think it's for everyone, Pak. So feel free to answer.
Yeah, yeah. I think every case has its own uniqueness, yeah, and its own technicality difficulties, yeah. But from our experience, the most challenging dispute is the dispute which involve technical matters a lot. For example, for the mining activities, for example, if the dispute is about the share transfer, it's quite easy. We easily can build up an argument that the transfer of shares is correct or not correct. Yeah, but the challenging one, if, for example, the dispute is on the coal loss, yeah, we have to build arguments and provide the documents on two things: on the liability. The liability means the substance that the service provider is in breach, and the second is on the, what we call it, on the quantum. The quantum is the quantity that the breach has done. What is the loss? What is the relations between the damage and the loss? What is the technicality of the thing? So I think technical dispute is sometimes challenging, and for that kind of dispute, usually a law firm will team up with a technical advisors or financial advisors to assess and to provide with the proper assessment on the liability on the quantum. Maybe Pak Kedista can share your ideas on what kind of the most difficult arbitration case.
Yes, thank you very much. I think a general question like this is always challenging to answer, but I think when it comes to difficult cases, from arbitration technical standpoint, it would be cases where the pleadings are not entirely clear. So it even the simplest mining transaction case can be very difficult to be decided if the parties are not fleshing out, are not setting out their case in a very nice, clear, concise manner that can be easily understood by the tribunal, by the arbitrators. So I think that would be, in my view, one of the most difficult cases to decide. The other one would be cases involving recalcitrant respondent or a troublemaker respondent that is not, that don't really have the intention of participating in the arbitration in good faith. They simply want to delay things. They don't want to give a proper answer. And when it comes to arbitration, there is this due process paranoia of the tribunal, because in arbitration, as in court litigation as well, but I think tribunals are much more sensitive in terms of giving adequate opportunities for parties to present their case. So if the respondent is evading, avoiding participation, and making things difficult, I think that is also a very difficult situation to deal with, even though, again, the mining transaction involved can be relatively uh, simple or not as complicated as it would be. Uh, and on the other hand, when it comes to very advanced, sophisticated mining disputes, of course, that would be challenging to decide. But I've seen cases such as that can be decided by the arbitrators fairly expeditiously, because these complex issues can also be how to say it, simplified with the presentation of expert reports, with the cross-examination of experts, so that basically the complex issues can be simplified and understood uh, relatively easier by the tribunal. So I think that's my take on the question, Nadira. Thank you so much.
Okay, thank you, Mr. Candista. And we actually have one more question, Pak Candista, like this one.
Okay, sure.
Do you mind to answer the question? One more question, one last question.
Yeah. Yes.
Yeah. So
Oh,
on
okay.
technical, yeah,
Okay, I'm looking at the question.
for sure.
Okay, this is an interesting one as well. When it comes to disputes, including arbitration, parties can rely on their own data and documents as evidence. What needs to be noted is that these data or evidence is usually they don't stand alone. They usually are accompanied with witness statements and expert reports, or saksi ahli, keterangan saksi ahli, and these witnesses and experts will be cross-examined by the opposing party and by the tribunal, so that the tribunal can really see which data, which documents makes more sense, and which one is more in line with the agreement, the original agreement of the underlying agreement of the parties, or the intention of the parties, and or the applicable law. So that's what is usually done in arbitration. uh, the second part is based on the past cases. How does parties come to agreement for the use of data? Again, I think basically each party can use their own data. There need not be any agreement on how to use it. So basically, who has a claim has to prove their claim, and they can provide any information or evidence or data that they think would buttress their claim, would support their claim, and then the tribunal will just decide, after examining all the evidence, all the law, all the witnesses and experts, which argument, which data is actually more reliable, more trustworthy, or more persuasive, or more in line with the agreement of the parties, more makes sense, and in line with the applicable law as well. I guess that's pretty much it from me, Nadira.
Okay, thank you, Mr. Candista, for the answers. Okay, so for everyone, I think we are done for today's session. So we would like to apologize for the inconvenience due to the Wi-Fi connection. Okay, so we would like to thank all panelists and also everyone attending our webinar today for staying with us throughout the session. And therefore, I would like to thank Mr. Dendi Adisuryo, Mr. Bazo Ashab. I think he's not here yet. And then Mr. Kanista Wanta and Mr. Hual Adolf, who is not available to attend to be here with us for the closing part. Thank you for the insightful presentation, as well as for answering the questions. And also to our participants, we thank you for your attention. We apologize that we couldn't answer all the questions that you have submitted, but hopefully we have covered some important matters from the discussion today. We have reached the end of the International Public Webinar in collaboration with ADCO Law 2021, with the theme, The Upcoming Trends of Mining Dispute in Indonesia. We hope to see you again in another webinar series.
Thank you, Nadira. Thank you, Pak.
Thank you all. Bye.
Thank you,
Bye.
Dendi.
Thank you.
all.
Thank you to the speaker. Thank you, Dendi, Candista, Nadira. Thank you.
Thank you so
you.
much, Pak.
Thank you.
Thank you semuanya.
Thank you so much, Pak.
Thank you all.
Thank you so much, Pak Dendi.